Hello, friends and clients. I am Jennifer Walker-Gates, immigration attorney with JLW Immigration Law Group. I am here today to talk about U visas and protective orders. We are going to be talking today about whether someone who obtains a protective order from a family law court is eligible to receive a U visa. This is really important for anyone who is a survivor of family violence because domestic violence is a qualifying crime for U visa purposes. Protective orders are technically not criminal proceedings, which is typically required for a U visa, but there are some important subtleties and nuances to understand about the relationship between protective orders and law enforcement. And we have been very successful dozens of times getting U visas for our clients who have obtained protective orders. So I want all of those folks out there who may be eligible, who may have gotten a protective order but told that they were not able to get a U visa with that. I want you to understand how this can work, and please reach out to us for help if you need it. We definitely want everyone in the US to get lawful status and be successful in your immigration goals, whether you're working with us, with another attorney, or on your own in your case. So for that reason, we are here publishing videos regularly, and we ask for your help to subscribe to our channel, share the video if you like it, and leave us comments if you have questions. I do respond to the comments, and I would be happy to respond to yours. If you need specific advice about your particular case, typically that we cannot give legal advice on the YouTube channel. However, you can definitely reach out to us. We'll be happy to consult with you privately and analyze your case, look very closely at the details, and give you tailored, customized recommendations for how to move forward in your particular circumstance. All right, so let's talk about U visas. I'm going to first talk about protective orders. And basically, there are two kinds of protective orders. There's what's called an emergency protective order that is issued when someone makes a police report and needs immediate protection from harm. An emergency protective order typically lasts for 30 days. It orders a perpetrator of violence to stay away, keep a minimum distance away from the alleged victim or victims, and authorizes police to arrest and charge this person who is the subject of the protective order with a crime, a separate crime, which is violating a protective order if they don't follow the instructions in the emergency protective order. Now, these don't last a really long time. And so if a victim really needs longer term protection from family violence, then they need to go get a judicial protective order. And a judicial protective order kind of does the same thing, except it brings the perpetrator into the courtroom. It brings the alleged, abuser into the courtroom. The victim usually has to face that person in the courtroom and ask for the judge's protection from harm from this person. Judicial protective orders can be issued for much greater lengths of time, up to 2 years in the state of Texas, and possibly even longer in some other areas. So for people who need longer term protection, a judicial protective order is crucial. Now, for U visa purposes, there are several requirements, and we're going to go through those basic requirements first, and then we'll talk about how protective orders come into play in this context. For a U visa, a person needs to show that they are a victim of qualifying criminal activity, of which domestic violence, family violence is one crime. There is a long list of qualifying crimes that someone can, if someone has suffered as a victim of one of those crimes, they can apply for a U visa. Others include stalking and certain types of harassment, but family violence is one that's unfortunately all too common and that we see a lot. We have to show that you are a victim of one of the crimes that's listed in the immigration law as a qualifying crime for U visa purposes. The crime has to have occurred in the United States, and it needs to have been reported in the United States. You also have to show that the victim has been, is being, or will be helpful in the investigation or prosecution of the crime. Okay, it's investigation or prosecution. That or is really critical because it means that a prosecution is not required. An arrest is not required. A report and cooperation from the victim in making a report and helping with any investigation that may or may not place after the report, that is the basic requirement to qualify for a U visa certification from law enforcement. Okay, so you have to show that you have been helpful in the investigation or prosecution. You have to show that you have suffered substantial mental or physical abuse as the result of being a victim of disqualifying criminal activity. And you have to show that you are admissible to the United States, meaning you don't have anything in your immigration history or in your criminal history that will prevent you from getting permission to stay in the US. If you do have any kind of smirch in your record, in your immigration history or in your criminal history, you can apply for a waiver unless that smirch in your record involves terrorist activity or national security concerns. Most of the time, what we see is that clients who have minor criminal and immigration infractions in their record are able to receive a waiver of inadmissibility for the U visa. The U visa takes a really long time to issue, but it's a great benefit because in order to receive the U visa, you don't have to leave the United States. Once the U visa is issued, you can be on the path to permanent resident status. And the waivers for U visa recipients tend to be very generous. So even people who have a permanent bar from multiple unlawful entries, people who have made false claims to US citizenship, these kinds of things that typically are complete deal breakers in the immigration law in other contexts, they can receive waivers if they are a cooperative victim of crime who has assisted law enforcement in the investigation or prosecution of a crime. Okay, so for that reason, we do a lot of U visas. I've been doing U visas since they very first started in 2006, 2007. I've done hundreds of them, and they're an area that I really feel like works well in the immigration law because the ability for a victim to seek justice and turn a terrible experience into something positive is really baked into the immigration law for U visa recipients. Can you get a U visa as a result of just getting a protective order? Never having made, let's say you never got an emergency protective order, you didn't make a police report, you just went for that judicial protective order. In Travis County, where our office is located, we have seen this be successful dozens of times. When we first began filing these cases, USCIS really fought us about this because they said, civil protective orders in a judicial context are not a law enforcement activity. This is not a prosecution, so this should not qualify. However, in Travis County, our prosecutors, there is an office of prosecutors with the Travis County attorney that prosecute protective orders, meaning they help victims apply for and receive protective orders from a judge. If a victim goes with the county attorney's office in Travis County, then they can request a U visa certification, and the Travis County attorney prosecutors will provide that law enforcement certification. You can also seek a protective order from a judge with a private attorney. However, a private attorney will not be able to offer you a law enforcement certification. So it is important to go with a public prosecutor if that service is available in your area. That is the key, really, because the prosecutors are the ones that have to sign off on the U visa certification. So if you go to them, you report the crime, they're going to make a record of the crime. They're going to create an in-depth record of your experience of domestic violence. Once the protective order is issued by the judge, then the county attorney's office is responsible for notifying police that there is a protective order in place. What that does is it allows a police agency to arrest someone for violating the protective order. So if they are ordered to remain a certain distance from a victim or from an address or from a child, then they can be arrested if they are caught violating that minimum distance, or if they continue to harass, communicate, or threaten the victim or any of the people named in the protective order. So because of the role of the Travis County attorney and the role that the protective order plays in notifying police that there is potential danger and that they do need to provide additional protection to a victim, immigration has long agreed with us that the protective order process in Travis County serves as a law enforcement process. It has a law enforcement purpose that is related to investigations and prosecutions, and it protects victims. It helps reduce domestic violence. And all of these things were intended to be effects and results of the U visa program. The U visa program was created so that people who are undocumented, who don't have lawful immigration status, can begin to trust law enforcement communities, report crimes, ask for help when they need it, and reduce crime in those communities. That is the purpose of the program. It's not just to benefit law enforcement for its own sake. It's not just to benefit immigrants for its own sake. It is to reduce crime in our communities, which makes everyone safer. For that reason, protective orders, if handled by a county attorney or a public prosecutor, really do work for U visa purposes. And it's important to understand how to make that happen. If we can help you at all, please don't hesitate to reach out to us. We would be glad to do so. We can help you look up the information that you need to make that initial request for a protective order. In the United States, no one has the right to physically harm, abuse, or threaten you. It doesn't matter their relationship to you. It doesn't matter your immigration status. They cannot take your kids away. They cannot force immigration to deport you. I know that these are common themes that we hear from many of our clients who are suffering in abusive relationships. And it's really important to understand that those are lies, that law enforcement can help you. And we also can stand by your side, hold your hand, step you through how to make reports, how to request protective orders, how to keep yourself and your family safe, and also seek immigration status that can help you remain secure and stable together with your loved ones in the United States. That's what we're all about. If we can help you do this, please reach out to us. We would be honored to do so. Our contact information is scrolling along the bottom of this screen, but I'll just say it here. Our website is jlw.law, jlw.law. You can go to our website and click at the top right of the screen to schedule an appointment with me or any of the attorneys in my firm. We would be glad to analyze your case and help you understand how best to proceed with it. And you can also call our office at 512-633-1785, and our wonderful team will help get you scheduled. Please reach out. Don't wait to get help. Stay safe. I hope this has been helpful. And again, share, subscribe, leave us a comment, and we'll talk to you soon.